Hey y'all, it's Sondretta Green, your go-to real estate agent here, licensed in West Tennessee and North Mississippi. And I am here with my friend Ryan Byrne.
Hello.
He is a real estate attorney. He's been a real estate attorney for going on 31 years. He's entered into his 31st year, and he is the senior partner at Byrne Westmoreland. So today we're going to do something a little different. Y'all are used to me telling you about real estate, telling you about the market, doing home tours. But today I wanted to do something really special. Then in my next episode, we're going to be doing something special as well. But today we're going to talk about trust and wills. I've heard so many celebrities and so many people, they pass away and they don't have a will lined up. They have all of these assets. And I don't want to just be that transactional real estate agent, because that's not me. I want to provide you knowledge and wisdom and value for one of your biggest assets. So today that's what we're going to talk about. And because I'm not an attorney, I got one of my favorite attorneys here with me. So Ryan, just tell us just a little bit about yourself.
Thank you. As you mentioned, I've been doing this for going on 30 years and found my way to real estate law through divorce law. Didn't like that very much. Found my way to real estate and really love it, because the goal in a real estate transaction is helping people, and everyone has the same goal and we're all in the boat rowing the same way. So I took to real estate law like a fish to water and love what I do, love helping people. And our firm, in addition to doing real estate closings, we have found that estate planning is a very good side practice to real estate. So we have an estate planning side as well, where we handle wills, trusts, powers of attorney, and everyone deserves to have an estate plan. Whether you own a home or not, you deserve to say what happens to your stuff when you are gone. And because we're dealing with the biggest asset people have in their lives, it is not a one size fits all. Certain people, a will is going to be good enough. Other folks need either a partnership or an LLC, and others need a trust. So it's an individually tailored thing that we do for people based on their assets, where they are in life, how many kids they have, what their marital status is, and where they own property.
Absolutely. And I know I have viewers from all over the world, so every state is different. So definitely check with one of your local attorneys, and everyone's situation is different. So definitely you always want to just get with an attorney. Rules and laws change all the time.
Yes, thank you for saying that. And I'll have to say a little disclaimer. Nothing that I say today should be construed or taken by anyone to be actual legal advice, because of that very reason. Every circumstance is different. So I'm not giving legal advice today. We're just going to talk about some broad concepts and options for you guys to think about.
Absolutely. So we're just going to have a conversation today, Ryan.
Sure.
So, I'm a real estate agent, so I have no idea as far as when you should have a trust, when you should have a will. I sell homes to people. I help people to sell their homes. And I know that this is definitely something very important. So can you definitely just kind of explain like the differences between the trust, the will, and, if a trust is necessary, when it is necessary?
Absolutely. When you buy a piece of real estate and you become an owner, again, you should be under the mindset that you need to have an estate plan. Everyone deserves to have an estate plan, because under the law, at least in this state, if you don't have a will or a direction in some way saying where your assets go, the state gets to decide. And nobody wants the state to decide anything. So, and the sad reality is probably 70% of Americans don't have anything. They die without a will, leaving a bunch of heirs, and it becomes a mess and a fight. And there's no need for that. So, a will is basically you're putting down your wishes. You're appointing certain people to handle your estate when you're gone. That person would be called your executor. And you're directing them to probate your will, take it to court, You would be sworn in as an executor, which would go before a judge saying that I'm going to follow the instructions in the will. You gather the assets of the person who's died. You pay off any taxes or any bills that they owe, and then you distribute the remaining assets to the beneficiaries or the loved ones left behind. So that's really the role of an executor, is to follow the instructions in the will. Now, a trust comes into play. A trust is a little bit different. Trusts are like setting up a corporation. Okay. A trust would actually hold title to your home, your car, your other assets. You would actually title those properties into this entity, and you would not be the owner of those anymore. Now, typically, you would set up yourself as the trustee to be able to maintain control over those assets, but you are technically not the owner of that property. Why do people set up trusts? Maybe it's for protection against creditors. Maybe it's a situation where you've got one spouse that is asset heavy and the other one is not. Maybe this is a second marriage where there are children from a first marriage that you need to take care of. A trust would be the best vehicle to do that. As long as it's not too complicated, you can put trust provisions within a will. A lot of people don't know that. So a trust is far more complicated, far more expensive than a regular will. So I would say a lot of folks probably have trusts that maybe don't have the assets to justify it. And then there are others that own a lot of properties that probably do need a trust. So again, that's just figuring out individual needs. But a trust would be like a corporation that's going to hold title to all of your property to get it out of your own name. It's mainly for protection against creditors and taxation purposes.
Okay. Wow. So I'm definitely already informed. Now, you mentioned something about the will and drawing up the will. And I know I've heard horror stories about certain persons saying, I'm mad at you, I'm going to write you out of my will. And they do 2 or 3 or 4 different wills or whatnot.
Right.
And so is there a certain place you need to store your will, or do you need to give it to someone to hold?
We recommend once we perform those documents and do a will and a power of attorney and those other estate documents for a client, we recommend, the days of safety deposit boxes at banks don't have those anymore. So we do recommend buying a fireproof safe and holding it in at least 2 locations. If something happens, you want to be able to hold the original, because as an attorney that prepares these documents, we used to have to hold signed copies of those documents for several years after closing. Then 9/11 happened, and they passed the Patriot Act. And what was included in the Patriot Act were a lot of privacy law changes that have to be made. And now, due to being hacked and internet security reasons, we don't retain copies of those documents. So when the client comes and gets a will and a power of attorney, they are walking out with the originals, and our IT department comes and sweeps our computers clean every 6 months. So the days of your attorney holding a copy of that's kind of over.
Okay. Now, how about at the court? Do you file it there, or you don't do that?
Well, that's something that they used to do really 30, 40 years ago. You would go and record your will in the county register's office. That's not really done now because, frankly, it's not your neighbor's business who you're leaving your car and your house and all that stuff to, and your assets. So you can do it. You don't see it done anymore, just for privacy reason.
Okay.
You don't want the world knowing that you've got a Charles Schwab investment account because every hacker on earth will try to attack that and find it and all that stuff.
Awesome.
So that it's important to keep that private. But you do want your loved ones, especially the ones you're appointing your executor, to know where those copies are, to have access to it. I'm not saying give a copy to everybody in the family, but the important ones that are going to need it, not a bad idea.
Okay, that's a great point. So now we're going to dive into home ownership. Someone who maybe just owns their own one property, not multiple properties. And what happens like when they pass away, if they die, like what happens to their home?
Well, when we get a closing order for someone who has passed away, there's some threshold questions that have to be asked. Did they have a will? And was that will probated? There's a myth out there that if someone died with a will, the will has to be followed. It only has to be followed when the executor goes to court and opens up a probate estate and takes the executor's oath before a judge. Then there is an open estate, the court is overlooking everything, and the will is then considered probated. 80% of wills in this country are never probated. You know, they're just not done. If that's the case, if you're not going to probate the will, then the laws of intestate succession kick in, and it determines who the owners of that real property are. So if you're leaving something, let's say you've got two children and one of them has not been a great kid and has no contact, and you want to leave them out, you probably need to put that in the will that you are leaving that child out, leaving it to your spouse and your remaining child. Then they would go to probate court and the judge would sign off on that. Because if they don't go to court, that black sheep child would have just as much of an ownership interest as the wife and the surviving spouse. So there are certain reasons where probate can't be avoided. But again, the main goal always is to have the property owner's wishes followed. You've worked hard, you've built it up, you've bought this property. What you want should be paramount to everything else.
Absolutely, absolutely. So the key here is for that executor to definitely go to the court and let the courts do their part.
Yes, and just to say, because I know you hear a lawyer say the word probate, and I know what's going through the viewer's mind right now. It's expensive, it's long, it's horrible, why do that? That's not the case at all.
Okay.
Typically, an estate is opened, and in Tennessee anyway, there's a minimum time it has to be open for 4 months.
Okay.
And that gives 4 months for any creditor that's out there, a Methodist hospital or a nursing home or TennCare, to come back and make their claim against the estate. The executor shows up one time when the estate is opened. They say their executor's oath, and then usually it's just handled by the attorney and it's open and closed in 2 visits. So I think there's this big myth out there that probate is some scary, expensive process. It's not. It's not. That's a myth that we need to debunk.
Okay. And I think you kind of covered this a little bit when we were talking about trust, but we're going to just ask this too.
Sure.
In this situation, would a trust reduce any delays, costs, or stress to your family if, when the individual passes away, or would a will be suffice?
Well, the good news is a trust is a corporation or a separate entity holding it. So you can't go to probate court on a trust. The property would pass according to whatever the trust document itself says. So a trust does eliminate the need for probate court. But again, the person that set up the trust is not technically the owner of that property. So they are giving up a little bit of control for that benefit.
Okay. Got it.
And it also protects against creditors as well. So if the property is titled in a trust and there are individual debts against the person that died, they can't come against the trust.
Oh, wow. So that's great. So that's why you're paying that extra money too.
Exactly.
To protect your assets.
Absolutely.
So let's talk about our state and I guess Tennessee and Mississippi as far as the homestead property, spousal rights, and elective shares.
Sure. Homestead is different in every state. We've got 50 sets of laws regarding homestead. And in Tennessee, there's very little homestead protection. The homestead is automatic. And when I say the term homestead, that means the person who died was living in this property as their primary residence, with or without a spouse there. So that is considered homestead. And under the law, we want to protect people's primary residence from creditors. So in Tennessee, the maximum amount that it protects you is $35,000 if you're single, $52,500 if you're married. And so that means creditors in some catastrophic lawsuit, creditors could take everything except the $35,000 and $52,500. How many of you live in a house that's $35,000?
Not anymore.
Right. So
Wow.
the reality is in Tennessee, there is very little benefit. It's almost non-existent. In Mississippi, homestead laws are different. You file for homestead and it does reduce your property taxes. It
Right.
gives you a credit on your property taxes, unlike in Tennessee. But again, that credit is also minimal. So if you're in a state like Florida, they have an unlimited homestead. In Florida. And that's why people move to Florida with all their money and build these mega mansions, because they know if they go belly up, that house is protected, whatever its value.
Wow.
Yeah.
Oh, learning something about Florida today.
For sure.
So let's say, for instance, I own a home and my name is on the home, and I got my will or whatnot, and I'm incapacitated, I'm sick, and just no longer here mentally. How do I manage my property? How does that work?
Well, part of an important estate plan, we've talked a lot about wills and we've talked about trusts, but even more important than that for an estate attorney is a power of attorney. And a power of attorney is a document that says, if I ever lose capacity or the ability to pay my own bills or take care of my own affairs, someone who I appoint has the ability to do that for me. So we have, and there's all kinds of powers of attorney. There's durable powers of attorney. There's powers of attorneys that are specific to just healthcare decisions. You can talk to my doctor. You can help me make my healthcare decision. There's financial power of attorneys. So you have to decide what works best for you. But a power of attorney would put you in a situation where someone is responsible for taking care of your affairs, paying your bills, being able to help in that way. So again, for a probate and estate planning attorney, powers of attorney are about 100 times more important than a will, because you're still alive.
Right. Absolutely. Absolutely. Now, as you know, I'm prior military, so I have a lot of military viewers, and we have Millington here. So I service a lot of military active duty and veterans. So in that instance, a lot of times people have multiple properties. They have homes all over everywhere they move, which is a smart move. So let's say I have properties in different states. How do I risk multiple probates if my properties are in different states, and how can I avoid this?
Well, the short answer to that is probably your probate is going to be opened wherever the person was domiciled and passed away. So if that's in Tennessee, you're going to have the main probate here. But if you also own property in Missouri and Alaska and California, whatever is filed in Tennessee, you would open up an ancillary probate just to prove ownership of that property in those states. Those states do not necessarily have to follow rules of a Tennessee probate court. So again, there's no real way to avoid it, but again, an ancillary probate in another state to bring property back into the fold, it's a quick and easy process. Any probate attorney in those states can help you with that.
Got it. So in that instance, if you have all these multiple properties, more than likely you have a lot of assets. So it would be wise to
start a trust. Have a trust. Absolutely.
Right. Because then that way you can avoid.
Yeah, you're avoiding all those extra probates in those other states.
So let's talk about property taxes, reassessments, homestead exemptions. How does that affect putting your property in a trust?
Yeah, if this is again going to be state specific. In our area in Mississippi, you reach a certain age where you get a reduction or an elimination of property taxes once you're a certain age. So that is titled in an individual name. Also, trusts cannot file a homestead because a trust is not an individual under the law. So any sort of thing like that, real estate tax discounts, or tax abatement programs for disabled, those things, once you take title out of the individual name, you're surrendering the benefits of that.
Okay.
So that would be the downside of taking it out of an individual name. Again, that's going to be specific to the individual.
Okay. Now, how about refinancing a property held in a trust? Does that create any complications?
Well, most of the time, a trust is not going to be a borrower for a lender. We do refinances all the time where the family, for estate planning reasons, has titled into the trust, and we'll get a title order for a refinance. And one of the requirements is we have to quit claim that property out of the trust and into the individual name, because the individual name is going to be the one on the loan. And then the lender says, just quit claim it back after you've closed. So we have done that many times. Take it out of the trust, put it back in their individual names, execute the new loan documents, record the new mortgage, and then put it back into the trust for estate planning reasons.
Okay.
Yeah.
That's
not hard. It's just takes a little bit of time and some planning.
Absolutely. So now we're talking about this other term, LLCs. And before we introduce this in a question form, can you tell us like a little bit about LLCs, like what's the importance of it, like when you should incorporate an LLC?
Sure. This all started, there's different ways to hold property. You can hold property in your individual name or have a business that is a sole proprietorship. And that just means you're holding it in your individual name. And if you are sued and get a judgment against you, that judgment creditor can take everything you own because it's in your individual name. Mm-hmm. And people that started going into business say, wait a minute, I need some protection. Let's set up a corporation. And so for a long time, everybody put their businesses into corporations to give a layer of liability. That way, if I am sued in my business, they can't take my personal house, my personal assets, my personal car. So it was done really for liability protection when you're running a business. Corporations have to be filed with the state, and they also are taxed and have to have their own tax returns every year. Mm-hmm. So that became very expensive because in Tennessee, it's $300 a year to pay the filing fee. Plus, then you've got to pay a tax preparer to prepare a tax return, not only for your individual self, but for your business. And it was tax-wise, it was becoming pretty expensive. So most states across the country came up with the idea of an LLC, and that stands for limited liability company. Mm. And it gives the person the flexibility to get all of the protections of a corporation, but they can be taxed either as a corporation or a partnership. So it gives them much more tax flexibility. And in all new entities, when we file these for our clients, I probably haven't done a corporation in at least 10 years. Everyone wants an LLC just because of the tax flexibility. I know your CPA is probably going to talk about that a little bit, about the tax aspect of it, but it's giving you liability protection to protect your personal assets from your business, which is important, especially if those assets are rental properties. Tenants fall, tenants get injured, and the first thing they want to do is sue the owner for something, whether it's the owner's fault or not. So when you get rental properties, 2 words here, probably get insurance yourself to the hilt, get insurance, and think about an LLC.
Oh, wow. You're giving us more nuggets, definitely. I haven't thought about that either. So how do trusts and LLCs interact when properties are income producing?
Well, again, you would have a document that governed the LLC. That document is called an operating agreement. So whoever the partners are in an LLC, at the inception, when it is set up with the state and the filing fee is paid, they would sign an operating agreement that says who's going to manage what. Are we going to have employees? What happens when one partner wants out? Are we going to have a buy-in? What happens if a partner dies? All of that's going to be determined in that governing document. So you've got to have a very good detailed operating agreement, not a 1-page summary that the 2 people just sit down at a kitchen table and write up. This is where do not go cheap. Get a lawyer to draft an operating agreement. Absolutely. It's very important.
Absolutely. It's your business, so definitely you need to, it's an investment.
For sure.
So now we're going to dive into partnerships. Like I was telling Ryan earlier, I have a lot of military members, friends, and just a lot of friends that are doing some great big things. It's a great time to just dive in with partnerships. And so when they have different multiple properties, when they're getting on the commercial side, when they're going into partnership with one another's, now we're going to kind of discuss that area. So what happens to my ownership interest if I die and I'm in a partnership with, let's say, 4 or 5 different partners. Does it go to my heirs or does it stay with the partners?
Well, like an operating agreement is to an LLC, a partnership agreement should be drafted for the partnership that should address those things. Obviously, if you've got a situation where a partner passes away or a partner wants out, you're going to need to know what happens. Is that partner responsible for selling their partnership interest to someone else? What if those remaining partners don't want to be in business with either a relative, an heir, a wife, or another investor? And so partnership agreement should address that. What happens when someone wants out? What happens when someone dies? Typically, whatever the interest is would pass to that person's heirs. But again, you would need to address that in your partnership agreement because, again, if you've got 3 business savvy people and they're going to be in business with someone who has just inherited an interest and don't know anything about the investment,
right,
that's not a comfortable place to be. It's not a good place to be at all.
Right. So that's just something that the partners will discuss and put in writing on the front end.
Yes. And again, the biggest mistake that I've seen in my practice is folks that are friends and buddies that get a little bit of money and they're like, oh, this is going to be fine. And they write down just bare bones agreement and sign it. And it doesn't even begin to address problems. And what will happen, and what I've seen over and over and over again, something's going to go south at some point and you don't have anything in writing. And so you've got 2 partners in business with each other, both going in different directions. And who's going to decide what happens? Probably a judge in a lawsuit. And so if you can avoid that by putting every possible contingency in a partnership agreement, that's what you need to do.
And so this is where I would say they should rely heavily on an attorney.
Absolutely.
Because an attorney that is very familiar with these things is going to just help them kind of think of things and certain circumstances and scenarios that they would not be thinking about.
Absolutely. This is not a place to do it yourself. And again, my job in sitting in with these partners and drafting these agreements, which I've done my entire career, is to not tell them what to decide, but to bring up, what about this? What if this happens? What if this happens? And they paint the picture. I'm just giving them the questions.
Okay. Well, thank you for that, Ryan. Do we need a buy-sell agreement tied to death, disability, or divorce when it comes to the partnership?
Absolutely. Whether it's a partnership agreement or an operating agreement for an LLC, yes, those things need to be addressed. Because again, you don't want to have an unintended business partner.
So basically that goes back to what you said earlier.
Yes.
Okay. You would go through these scenarios with them, the partners, to make sure that they're aware of these things.
Exactly.
They have them in place. So how is property value at death for buyouts or transfers?
Well, I can just tell you in the way my business, my law firm, I have one business partner. And in the event of either one of our deaths, the business has to be valued. So we would get an appraisal of the business or the property in question, what we're talking about. And typically it would be either 2 or 3 appraisals because an appraisal is just an opinion.
Yes.
One appraiser has one opinion, someone else has another opinion. So typically we would put a provision in there that says that both parties are going to pay for an appraisal and they'll average the 2, or you get 3 and all of them are averaged. It's whatever they agree to. But again, the more detailed they can be on that, the more likely you are to hit the value pretty well.
Oh, awesome. Awesome, man. I'm learning a lot. So,
and others I've done where they hire a realtor and you do a market analysis and you give them the value, and that saves, an appraisal now is $450. So there are different options, lower cost here, to use a professional that knows what she's doing.
That's right. That's right. So now let's say I am in partnership with my business partners and we've agreed that, God forbid, if something were to happen to me, it would be my husband would take over. It would be, what do you call that? It would be transferred. My ownership would be transferred.
Inherited to your husband.
Inherited to my husband.
Right.
See, I'm not an attorney, y'all. So with that being said, let's say, would my husband be able to force them to sell the business, or can the partners force him to buy him out?
Well, again, that would be what is in that agreement from the beginning. If I were in a situation where my business partner passed away and his wife came in at his death and tried to force a sale, I'm not done working yet. I want to keep this going.
Right.
So it's just a matter of what you put in the agreement from the very beginning to deal with that. Typically what happens is that interest is whatever the value is bought by the remaining partners, and that person is your heir. Your heir is paid for your value. It is rare that you're going to allow someone who's not been a part of the business to step in and start making decisions on a business that they've not been involved with. I certainly wouldn't want to be in business with my partner. I love her, but don't want to be in business with my partner's spouse.
Right. Absolutely. Absolutely. So now let's talk about ownership interest as far as a trust or a LLC, operating agreement. How should that ownership interest pass through? Should it pass through a trust, an LLC, or operating agreement, or all of the above?
Again, it's going to depend on circumstances. That's going to be an individual thing. I get a lot of seniors that come to me and their spouse has passed away and they're the only one entitled to a home. And they come to me and say, what can I do to avoid probate? And one of the things we can do is we can quit claim the property from that individual to themselves and a child with a right of survivorship. And that means at the parent's death, the property automatically passes to the child without any court being necessary. So if it's individually owned, that's one thing. If it's in a partnership, the partnership agreement is going to say what happens to the property. It also is dependent on how that property is titled. So, partnerships generally give both partners in a general partnership the authority to bind the company. So if you're going to go the partnership route as opposed to filing and doing an LLC, you had better know who you're in partners with, because there's a lot of trust that goes along with it in that type of entity that it really doesn't apply in an LLC, because they're going to have to abide by a written operating agreement. So just know who your partners are before you throw money together.
And that's a good point. I'm glad you brought that up. I think in being in business is sometimes when you're working for friends or you're working with friends that become your client, or now you're in partnership. It's tough for a lot of people to be able to separate and say, I know you're my friend, I know you're my loved one, but this is business. This is a contract. This is my job. I'm taking off my friend hat or my partner hat, and now I'm putting on my business partner hat, or now I work for you and this is my job.
It's the biggest mistake people make, is that everyone goes into a new venture with a new partner. It's all positive and good and it's going to be great. And I know it might be, but they need to pay me to be the devil's advocate here. I need to think of worst case scenario. If this happens, what do you want to happen? So I'm sort of the wet blanket in the process, but I'm glad that I am, because people need to discuss these things, because what's great in the beginning, sometimes it goes south and you don't want to end up in court with your friend / ex-partner.
Absolutely. So 2 things here I'm hearing, everybody, is that when you go into partnership, an agreement, an operating agreement, an agreement is very, very crucial. The more information you put in it, the better. And also, don't do it yourself. Ryan always tells us realtors, you are not an attorney, you are not a lender, you are not, stay in your lane. So with all of that being said, it is as imperative to get an attorney, go hire an attorney, sit down with your business partners and do the right thing.
It's a legal relationship. When you go into business with someone, it is a legal relationship. And just like I would not go to your CPA's office and tell him how to work up my tax return, he's not going to come here and tell me how to set up a partnership agreement. This is not a place to cut corners.
Right. Absolutely. Absolutely. So, Ryan, what mistakes do you see investors? What are some of the common mistakes that you see most investors make in estate planning?
First and foremost is probably by not doing one, by not having one. The overwhelming majority of Americans have nothing. And you're leaving a mess behind, and you're leaving a fight behind, and all those assets that person has worked so hard to acquire. You don't want a bunch of relatives coming out of the woodwork fighting over it, and that ends up happening is everybody's paying attorneys ridiculous sums of money to fight over asset value that is dwindling every single day. So the main thing is get an estate plan. Everyone should have one, period. That's just so important. And it's not a long, scary process. We make it very easy. We do most of this by telephone and email. When we bring people in, if it's a little bit more complicated, but a lot of it's all about communication, and having an estate plan is critical.
Okay, thank you, Ryan. Now, with having those things in place, we got our will, we got our trust, we got all of our information, we have our business plan, not our business plan, but we have our partnership, and we have our agreement, and we have all those things together. How often should we plan to review these things, review our portfolio if it grows? And how about the laws changing? Like, how does that tie into?
I think a fair answer to that is probably annually. If you have an LLC or a corporation or any other entity that's required to be filed with the state, there is an annual report that has to be filed and an annual fee. Just like a tax return, we have to file tax returns every year. Once a year minimum. Have a meeting with your partners, make sure everything's okay. If you've acquired properties or sold properties in the year, have those discussions. What are you going to do with those extra funds? Are we going to distribute them? Are we going to invest in something else? Don't just assume that everything's great and go 3 or 4 years without having a sit down face to face.
Yes. So now, the reason why I did this, it's just important. I want to make sure y'all are armed with this information. We hear it in the news with celebrities all the time. And so if it's happening with them, I know that it's happening with our loved ones.
Absolutely.
It's happening with people that I know, love, and trust. And I want to make sure you're armed. So I want to go back to this last question. And I want to ask this. In the event, unfortunately, that after you've seen this great video, you've been informed, and you fail to get a will, or you fail to make sure your assets are secure with a will or trust, what happens if an individual dies and they didn't have a will and they got all of these properties, or they just have their one home and they don't have a spouse or anyone or children? Like, even if they have that, like, what happens?
Well, then the state decides what the interest of property were.
So what does that mean, Ryan?
These are called the laws of intestate succession. And when someone dies with property, the state gets to say who the heirs are, and it's in relation with how close they were to the decedent. So if you died and a lot of folks think that your spouse gets everything at your death.
Right.
That's not the law in any state.
That is a misconception.
Okay. That is a big myth. What it is the spouse would have a share, any children would have a share, and then any children of deceased children would also have a share and step into the place where their parent would have taken. So it can be very complicated. I had a closing last week where there were 8 heirs and there was an estranged spouse. These folks had been split up for more than 32 years. She had not seen her husband.
Not divorced?
Not divorced, did not get a divorce. And what a surprise to the children that had to take care of this man for the last several years, that the wife has has ownership and has to sign off on everything. They didn't even know where she
Wow.
was, and boom, she gets 1/8 of that estate. So, yeah, it's something that those are loose ends that you don't want to leave.
Wow. Well, thank you, Ryan, so
Thank you.
much
Thank you for having me.
for doing this.
Thanks.
I appreciate you so much. And
Hey, if any of your folks want to contact me with specific questions, I'm happy and happy to help.
absolutely. Thank you, Ryan.
Thank you. Thank you,
Thank
love.
you. Thanks, yeah.